The learned counsel for the appellants oblique plaintiff contended that the appellants produced six witnesses, including the postman and postmaster full stop. The respondent only produced and no independent witness, yet the trial court dismissed the suit on basis of issues number 1 and 5 regarding and thereby committed an as positive findings qua issues number 4 and 6 in favor of the appellants, plaintiffs holding that powers of attorney as violated and non-filing of appeal or cross objections, these issues attained finality, and now, therefore, cannot be permitted to be argued or challenged, therefore, the dispute be limited to issues number 1 and 5 only, full stop. There is a little difference between and the other two appeals, as superior right of preemption of the plaintiffs also has not been expected therein, full stop. Thereafter, the learned counsel for the appellants stated that and 6 affirm the stance of the plaintiffs oblique appellants, as the receipt of the post office is on record as Exhibit P1, notice of Exhibit P2, copy of registered envelope as Exhibit P3, copy of acknowledgement due to. Thus, the plaintiffs oblique appellants adequated discharge, full stop, but it concurrently was ignored by the courts below, full stop. The counsel thereafter stated that the testimony and evidence of Exhibit P2 clearly reflects upon, full stop, it is a due performance, there is nothing on record to show that these witnesses were cross-examined on this point, thus, under the law of civil proceedings, anything which is not cross-examined is deemed to have been expected, correct, therefore, full stop.